Hi guys, as you see, I probably on my timeline there I did a test video. As you are aware, we had a few difficulties yesterday with the technical side of things, so apologies for that. If you do happen to see my video from yesterday, you can receive live notifications. So if you go onto that video, and in the top right hand corner there's three little dots, and on there it says turn on live notifications. So if you do want to be part of the Facebook legal surgery, the live legal surgery every week, if you could turn on those notifications, and you won't miss out on anything. So again, apologies for yesterday, but hopefully we won't have any issues moving forward. Now I will be answering your questions, anything that comes up at the time. So as I've mentioned before, how it works is that I will answer any of your queries as they come up. And if you have anything specific, you can either ask me at the time, or you can send me a separate message, and I can either respond to you directly, or you can, or I will respond to you at the time. So the whole idea of it is a general ease of getting advice and legal advice on various different matters. So my background is I've been in the legal profession for 15 years, qualified twice, and still continuing to learn. My specialities are property and private client work, so property aspects are sales, purchases, remortgages, transfer of equities, equity release, that kind of thing. And from the other side aspect, it's wills and lasting powers of attorney, things like that. So on the previous surgery, there was a few very good questions asked, and as a result of that, I did a guide for the conveyancing process, which will be on my page if you want to go and have a look at that. Yesterday I did do a video about the intestacy rules, so if you do, the intestacy rules apply where you haven't got a will and someone's died. So again, there'll be a flowchart which will be uploaded shortly for you to see that, and that will give you guidance and perhaps inspiration to do your own will if you haven't already got one in place, or a member of your family needs help with that. Since the surgery yesterday that didn't quite go as planned, I did have a question, so I thought I'd just address that point today for anyone who might be interested. And the question was, if you are an attorney for someone, does that entitle you to a copy of their will? Now, the standard provision is that it wouldn't entitle you to a copy of the will unless it's stated so in the lasting power of attorney. So what you'll need to do is check what the provisions are contained within the lasting power of attorney, and then if it says that you're entitled to one, then by all means apply to the solicitors or whoever's holding it for a copy. If not, then unfortunately you have to wait until that person's died, and if you are named as an executor, you can supply the death certificate, and they should supply the original will to you with your identification, things like that. So just to clarify a couple of points, the terminology of executor and attorney. So an attorney is someone who, under a lasting power of attorney or an enduring power of attorney, has the authority to deal with your assets and things during your lifetime. They will also deal with things to do with your health and welfare and things along those lines. An executor, on the other hand, deals with your estate after you have died. So those terminologies can get crossed over. The lasting power of attorney ceases on the death of an individual, unfortunately, and then the executors will step in. So thanks, guys, for your messages that you're putting on as well. That's very nice of you. So that's the difference between those two. But if you have any direct queries, then of course let me know. Yesterday the poll was won by the intestacy rules, but as I've already done a video on that, I won't bore you by doing it again. But today's topic will be, in the absence of any questions, which I can't see any so far, but if you do have anything, then please just ask. So the topic today is stamp duty. Now, stamp duty, the official title is stamp duty land tax. It's slightly different in Wales to England, so today we're just going to focus on the England, and so far as residential properties are concerned. There are different guidelines and thresholds relating to commercial transactions, so I would leave those for another day, but again, if you have any questions, please do ask. So the stamp duty rates, I have got a few things that I'll be putting up to help you understand this, but my favourite subject too, Inga, thanks for your message. the standard rates for stamp duty used to be quite straightforward, and it was a percentage, and it was a percentage of the purchase price, and it went up. Now we have thresholds. So for a main residence, the standard stamp duty land tax rate from 0 to 125,000 is 0%. So you don't pay anything on that amount. From the 125,000 up to 250,000, and any apportionment of that amount that you may be buying for is at 2%. 250 to 925,000 is 5%, and 925,000 to 1.5 million is 10%, and above that is 12%. So it can be quite complex because each section is based on that particular amount. So in any transaction where it's a main residence, 0 to 125 is 0%. And that will be the same. So if you were buying, for example, for 150,000, you would pay 0% on the 0 to 125, and then you would pay the 2% on the difference, which would be the 25,000. So that is how the stamp duty is calculated. I have done some calculations for you, which I'll go through just to show the difference. Now, there is an exemption, a partial exemption for first-time buyers. So there are different criteria what constitute a first-time buyer. It needs to be your sole main residence and for residential purposes only. You can never have owned a property in the whole of the world, not just the UK, and that applies to you or your spouse. And you can't be claiming any other exemptions. So it's quite specific, the criteria that you have to fulfil being a first-time buyer. But you do get the advantage if you are a first-time buyer, is you don't pay any stamp duty up to 300,000. So I have done a calculation, but it's going to be difficult to read because it'll be backwards, but I'll upload this for you. But you do pay stamp duty on any amount over 300,000, and it is calculated accordingly. So the other alternative is if you have a second home. And now if you have a second home, you do pay higher rates of stamp duty. It's actually an additional 3% per threshold. So the 0 to 125,000 threshold is actually calculated at 3%. So if you're buying above that, the amount additional tax you'll be paying on that particular part will be £3,750 extra. If you're buying between 125 and 250,000, it goes up to 5%. If you're going 250 to 925, it goes up to 8%, and so on. So it's an additional 3% on the standard threshold. Now the difference is on that. If you were buying a property for 300,000 on the main, if it was your first property, you would be paying stamp duty at a rate of 5,000. If it's a second or subsequent property that you already own, then you'll be paying 14,000. So you can see there's quite a substantial difference between the amount of tax you're paying. Now, the higher additional rates relate to whether or not you already own a property. So if you're buying it as a second home or a buy-to-let, or if you're purchasing as a company, that's when you pay at the second or subsequent rate. If you own a main residence and you own a buy-to-let, but you're selling your main residence and buying another main residence, even though you're keeping your buy-to-let, you would pay the rates as if it was your first and only main property. You pay it as a main property threshold, so it's at the normal rates. If you wanted to buy another residence before you were able to sell your property, you can do that. You will have to pay the higher rates of tax, but if you sell your previous main residence within 3 years, you can actually claim a refund on the difference. So in the example I used, if you were paying 14,000, if you were buying at 300,000, if you ended up paying a high rate of 14,000 and then you sold your main residence within 3 years, you could claim back the difference. So if it was just your main residence, it would be 5,000. So the difference you could claim back is 9,000, which you can do as long as you've got the land transaction return number. You can do it online, HMRC, and they deal with the refund directly with you. It's quite straightforward, but again, if you need help, your conveyancer or I can help you with that. It's not a problem. There's been many successful claims on that, but it's only if you're selling your main residence. As you can tell, it's quite a complex area, and I've just literally briefly touched on some of the main points. But if you have questions, then please do ask. There are loads of online stamp duty land tax calculators which are really, really helpful. It's good to do all the calculations for any potentials. Any conveyancer that you instruct will be able to give you a quote based on either scenario. As I say, this just purely relates to residential, so any commercial transaction as such will be, and when I say commercial, if you bought a plot of land, there's no residential property on it, that would also count as commercial. There's different thresholds, and there are advantages to that. So that's really what I'm going to cover in stamp duty. I will upload a blog to give you the details, and I will upload the examples that you can see the difference and the thresholds of what you'll be paying. Thanks for watching. If you have any questions, as always, please feel free to message me. You can either do it directly, you can do it as part of the Facebook Live. I will see you again in 2 weeks, and it will be correct next time without any issues, any backward screens, anything like that. And don't forget that currently I'm running a discount for wills in the month of January. If you use the code JAN2019, all the details, generally, that's just my social media following, so all the details will be on my website, www.eco-wills.co.uk. Like I say, any questions, let me just check we haven't got any. Excellent. So nothing at the moment, but any queries come through to me. It's Lucy Beck, the lawyer who listens. Thanks very much.